Hello friends, Namaskar, I am Anil Kumar Srivastav present with you with the questions of polity. I shall today discuss the Indian polity questions, and first of all I shall discuss the reservation in the light of the two important cases decided by Supreme Court. The first case was decided in 1993 known as the Indira Sahni case. The Supreme Court has laid down the following guidelines or decisions while deciding the section 16 clause 4 of the Indian Constitution. It has said that the 16.4 must be identified by cost, and the cost will be the major criterion for the decision for identifying the profit or eligibility under 16.4. And it also said that economic criterion shall not apply for the application of the section 16.4, and that is the Supreme Court has struck down the criterion of economic criterion for the application of 16.4. And the next point, the Supreme Court has said that as far as the 16.4 and 15.4 is concerned, 15.4 is concerned with the socially and educationally backward class of citizens, SC, ST, etc. But here in 16.4, here we find that the section talks about the backward class of citizens. So there are 15.4 and 16.4 are totally different sections. So next point, the Supreme Court has said that there should be no reservation more than the 50%, that the 50% should be the ceiling for the reservation, and in special very extreme cases this limit can be extended. And Supreme Court also said that there should be no reservation in promotion, and next Supreme Court has said the carry forward scheme can only be applied for the vacancies where it does not overtake the ceiling limit of 50%. So with these decisions, the Supreme Court has decided this important case in Indira Sahni case. But in 103, the Indian government has made an amendment, 103 amendment, and that is why it has substituted 16.6 in the Constitution. And the 16.6 was made for the educationally weaker section of people or society, EWS, underprivileged section of the society. But this case was challenged by in the Janahit Abhiyan case. In Janahit Abhiyan case, the 4 questions were to be decided by the Supreme Court. The very first question was whether the socially and educationally backward class citizens, SC, OBCs and STs also qualify for the EWS reservation, that is equal to 10%. The first question. And the second question was that whether the limit of 50%, which has been decided by Supreme Court himself in the Indira Sahni case for the reservation, should be maintained or not. And the next question was whether the category of these people will be included, SC, ST, OBC, etc. should be included in the EWS or not. And lastly, the one important question that was put forth was a private institution which is not getting the aid of the government aid or government funded can also get the EWS benefit. These 4 questions were before the Supreme Court when the 103 Amendment Act has been challenged. The Supreme Court has decided as the following. In the very first question, the Supreme Court has very in a very emphatic manner by 3-2 majority has held that the 103 Amendment Act or Section 16(6) does not violate any feature or essential feature of the Constitution, and it is not violative of basic structure of the Constitution. It is singularly structured on the correct basis of economic criteria. So economic criteria is by making the government has made a provision, a positive provision for the economically weaker sections. So it is valid and it does not violate any important provision or essential policy or basic structure of the Constitution. Secondly, Supreme Court has said whether the SC, OBC are socially and educationally backward class of citizens or backward classes also qualify for this EWS quota, or they will be excluded from this. The Supreme Court has said that the Section 16(4), Section 16(5) and 15(5) all talks about the reservation of the SC, ST, socially and educationally backward class of citizens. So reservation quota is covered by these sections. So the section, these sections are exhaustive for the reservation. As far as the SC's reservation, OBC's reservation, or socially educationally backward classes of citizens, or ST reservation, so this limit is fixed. But the reservation in the section is not exhaustive. Section is exhaustive for the SC, ST and OBC, but not exhaustive for the reservation. Since the government has made a new reservation a positive section, and that is why a distinct clause has been created, and that clause can be given the right of it. And in answer to the last question, the Supreme Court has said whether an institution which is privately funded can also be a quota for the EWS or not. The Supreme Court has already said that we have been in different cases also said that India is a socialistic society. In the preamble of the Constitution, we find that we talks about the social, economic and political justice, and in that principle of state policy bill also talks about the social, economic and political justice. So these all sections contribute that anything which is done for the social, economic, political justice should be the an important policy for our developing society, and it is well within the meaning of the provisions of the sections or the root, or it is enshrined in the roots of the Constitution. And because we are a developing society, we are a democratic society, we are society where social, political and economic justice is to be given. So Supreme Court has said that in the institution which does not get any kind of aid, government aid, and not funded by the government, and it is funded totally by the private, then reservation provision can also be made for the admissions in that institution. That's all for today. As far as the reservation is concerned, we shall meet you in the next episode for the polity for important criterion. Thank you very much.